Okay, so in those videos there, we saw about the Madrid system, which we're going to look at now. So the Paris Convention was where we left things the last day, and this was a deal between countries to recognize the rights of foreigners as this being the same as nationals, and also it set up a minimum set of requirements and protection and stuff. And this is where we left things. And we noted that Ireland signed up initially as part of the United Kingdom and then signed up in its own right again in 1925. Now, so in order to become a member, in order to sign up to the Paris Agreement, you had to agree to minimum sets of protection. And over time, these requirements eventually led to harmonization between the different countries. So some countries, if they had a very, very different trademark system from everyone else, in order to sign up, well, they needed to go and change it so that they offered the same minimum protections. And this meant then that with time, the trademark rules for various countries became quite similar. Okay, so when you look at the text of the law in Australia or the text of the law in New Zealand, you find they're actually quite similar, and that's because they have as their base this Paris Convention from 1883. Now, so the Paris Convention harmonized the law from country to country, and it also gave foreigners the same rights as locals. But if you were French and you wanted your trademark protected in the UK and in Germany and in Argentina and in Brazil, well, you still had to go off to the German trademark office and fill out your paperwork in German. You still had to go off to the UK and fill out your paperwork. You still had to send someone to the office in Buenos Aires and do that there, and you still had to go and send someone in Brazil to file your paperwork there. So although you were entitled to get protection in all of these countries, it still wasn't all that easy. So not long after the Paris Convention, they came up with this agreement. It was in 1890, so this is well over 100 years ago, to simplify the registration process in multiple countries. So that if you wanted to register your trademark in 20 different countries, it would be simpler. And so this agreement is still in force today and is administered now by the World Intellectual Property Organization, or WIPO. So with the Madrid Agreement, a citizen of a signatory country can apply to the WIPO to have a trademark that is registered in his home country to be registered in other specified countries. So you get your French trademark, your trademark has been registered, now you can apply to the WIPO to have that registered here and here and here and here and here. Okay, so the WIPO then forwards the applications to the national trademark offices, the various offices that are involved, and then that will be processed according to the national rules in each place. So if you have a trademark that for some reason would not ordinarily be registrable in Argentina, then it's still not registrable in Argentina. The Argentinians are going to say no, but the process is simplified. If there's an issue, you might have to engage with the national offices in the local language, but generally there shouldn't be one, and then the national offices will eventually get back to WIPO within a time frame to say you got it or you didn't. So it's a sort of a clearing house, like almost for clearing checks. It's a one-stop shop to get your trademark registered in lots of different countries. Another handy feature is that the renewal date is the same for all of them. So if you have to renew on the 12th of January, it'll be the 12th of January for all of them. So that's just one date you have to have in your calendar. And so it simplifies the process. Now, there is a problem though. If the registration in your home country is cancelled for some reason, so I got my French trademark, I went off to WIPO, got them in all the different places, and then after that, my French trademark was cancelled, well then all of the international registrations that were based on that are gone as well. So if I was your competitor, for example, I wanted to make life difficult for you, it'd be great crack for me to get your original one invalidated, because then you'd be screwed everywhere. Okay? But 5 years after the international registration, though, you're in the clear. So even if the original French one failed, provided you had the international ones for 5 years, you were grand. I've done here, it says 20 years for the registration. The video there we saw 10. I could be wrong. We'll see. No. So this was the agreement from 1890. It wasn't a huge success. So France, which is why I was using France as an example there and not the UK or Ireland, well, not Ireland anyway, because that wasn't around then. But France, Spain, the Netherlands, Italy, they all signed up. But notable absences to date include Ireland, the US, the United States, the United Kingdom, Australia, and so on. So it didn't take off. It didn't take off for a couple of reasons. So many years later, in 1989, so we're talking nearly 100 years on, we got the Madrid Protocol, which was a second crack off making it work. And so the process under the Madrid Protocol is very, very similar, but there are some key differences. So basically they jigged it a bit to try and get more people on board. So under the Madrid Protocol, you can apply for your international registrations as soon as you've applied for your national one. So I can go off to the Patents Office and apply to register my trademark in Ireland, and then straight away I can go off and specify that I want my French and German and Italian and Australian and American and whatever. So I don't have to wait till my trademark is granted in my home country. I don't have to wait until it's registered. And that's a big deal, especially if you're in a country where things move slowly. So if it was going to take like a year or two for your trademark to be registered at home, that's a long time to wait before you can start expanding out into other territories. Whereas I can apply to register my trademark today, and I can apply then to have it registered in all these other countries tomorrow. There was also a kind of a redistribution of the fees. It seems part of the reason it wasn't a huge success where there were money issues. I think maybe the national offices might have been losing out and not getting quite enough cash from the deal. So that's been rejigged a bit. And so now we have all the EU countries are signed up to the protocol. We have the US, Australia, China, and India. Two notable are exceptions, which is unfortunate because I plucked Brazil out of the air a minute ago by way of example. Brazil isn't in the protocol. So it's in neither the protocol nor the original one. And Canada isn't either. So to get your Canadian trademark, you still have to send someone, still have to fill out the paperwork on their website individually. And the same for Brazil. Okay. Again, the applications are made through your home office. So if I wanted to do this, I would use the trademark office in the country where I registered my trademark. So I'd do that in Ireland, and then I'd apply through them to get the international registration done. Countries can refuse to register your trademark within 12 months, or some have specified 18 months. But it means that you know you have it or you don't fairly soon. So if I was planning the rollout of a new super cool phone that was going to have a new super cool name, I could register that in Ireland, then try all the international registrations, and I'd know within 12 or 18 months which markets that was going to work in or not for me, where it was going to fly. Okay. If they don't get back to you in time, it's deemed to be registered, so they have to get back to you in that time period, and it's 10-year registration periods. So again, it means that you'll have one date to register. Every 10 years you pay the fee, you'll have them for another 10 years. But if the application fails in the home country, okay, you can keep the date of filing in your home country. That's important because that's called a priority date. That's important because if two people go to register the same thing, the person that got there first gets it. So if you go to register this in January and then someone goes to register it in Argentina in February, and then in March you find out that your Irish one wasn't successful, well, you get to keep the January date, so the person who went in February is still too late. That's something that didn't happen with the previous system. So these changes make it more attractive. So it's really just a more efficient way of getting trademarks registered in a whole bunch of different places. And the Swiss organise that. They're great at organising the old Swiss. Now, some countries then have decided to go even further with their harmonisation efforts. So the Paris Convention, was protections and minimum standards and equal treatment for foreigners. The Madrid system, really just a bureaucratic mechanism for registering in lots and lots of different places. Okay, but some groups of countries have decided to pool together the rules and the office and try and get economies of scale. So the Belgians and Luxembourgers and the Netherlands, the Benelux countries, were the first people to do this. So they decided back in 1962, look, we don't need a trademark office for Belgium, a separate one for Luxembourg and a separate one for the Netherlands. What we'll do is we'll get together, we'll agree what the law and what the rules should be for trademarks in those three countries, and then we'll have one office between the three of us, which I guess dealt with things in French and Flemish. Okay. So from a trademark point of view, Belgium, Luxembourg and the Netherlands is one country now. So there's no such thing as a Belgian trademark. You get a Benelux trademark, which covers you in all three of them. Some African countries got together in 1977 to try and do a similar thing. I think they're mainly the French-speaking ones in North Africa. And so they agreed on the rules for trademarks, and then you can apply to the one office and the trademark will be valid in all the different places. And some Latin American countries did the same. In the EU, of course, we have major harmonisation. So you're probably too young to remember, but there was a time before the single market. So there was a time when you couldn't just move something from Germany to the Netherlands. You had to stop at the border and had to be checked, and you had to pay import duties, or whatever the case may be. And then in 1992-93, we introduced the single market, which meant that goods could move freely throughout all of the EU. So you can ship something from Cyprus to Berlin, and there's no taxes, there's no import duties or anything like that. It was decided that in order to facilitate the single market, we needed to have more similar rules for trademarks. So in 1989, there was a directive issued that required the member states to harmonise aspects of their trademark rules. And this was considered necessary for the functioning of the single market that was coming down the road. So this is why if you go to the Irish Trademark Act and the UK Trademark Act, it's like they were copying. They weren't actually copying each other, they were copying the directive, which said you need to do this and this and this and this. And in English, it looks pretty much the same. So as a result of that, then, all of the different countries in the EU have very similar trademark rules. So even though the Paris Convention made them quite similar, this went a whole other level, and the law now in Finland and in France and in Ireland is all very similar. Okay. They went then one step further, and there was a regulation from 1994 which set up the community trademark system. And this is a trademark that applies across all member states of the EU, and it's treated the same as a nationally registered mark by the national courts. So it's very different from something you might do with the WIPO, where you apply for a French one and you apply for a German one and you apply for a Spanish one using the same form. This is a single trademark that applies across the entire EU. So in Ireland, if something is protected by a trademark, it could be protected by an Irish trademark, or it could be a community trademark. The courts will treat those the same, will recognise them both, but the community trademark will apply equally across all the member states. Now, the EU used its authority to regulate the single market as justification for doing this. And this harkens back to the trademark cases in the US, where the federal government had to say, well, look, we accept that states have their own individual rights and their own individual systems, but we have a role in regulating the single market. So we have the competence to have a federal trademark system. And similarly in Europe, the Commission said, well, we need this in order to have the single market working properly. So the Trademark Office, rather than being called the European Trademark Office or something like that, was called the Office for Harmonisation in the Internal Market. So it really didn't want to stray too far from its role as harmonising the internal market. So that office was set up to administer the community trademark system, and they put it in Alicante, which is a rather nice place to put it. So if you're looking for work placement, for example, they're very good for taking people on. So you could do your work placement in Alicante instead of, some place in Cork. So it's worth considering. So it's the central office for administering this harmonised single community trademark, and it's in Alicante. Now, a new regulation then in 2015 did a number of things. One thing it did was it finally did away with the somewhat cumbersome name. So after 20 odd years, whatever, it was a bit more confident of its role. And so now it's called the European Union Intellectual Property Office. In a lot of the documentation for court cases, you'll still see OHIM. But that's now known as the European Union Intellectual Property Office, or EUIPO. This was actually done almost a year to the day. I think it was the 23rd of March. What are we at today? 20th. So they even took ads out in the newspaper in Alicante just to let people know, look, we've changed our name. We're now the EUIPO. Okay? The community trademark is no longer called the community trademark. It's called the European Union trademark, or EUTM. But if you get a book out of the library, or if you look up something online, you'll still see the terms OHIM or even OAMI, and community trademark. There were also some changes in the law, but since you don't even know what the law says yet, I won't bother telling you what the changes are. We'll look at those a bit later. Okay? So, now in Europe we have 2 trademark systems on the go at the same time. So there's the national trademarks, so you can get an Irish trademark, a UK trademark, a French trademark, a German trademark, a Spanish trademark, an Austrian trademark, and each of those trademarks will be valid in those countries only. You can also get an EU trademark which will apply across all of the EU. But that's very, very different now, just to be clear, from this bundle of trademarks that you can get from the IPO. You can still go after the IPO and say, I want an Irish one and a French one and a German one and a Spanish one, and list off all the countries you want. But this is a single one that applies across all the EU. So we had then in the past, if we look at this lovely map here, a whole bunch of different trademark regimes where different countries had different laws, different emphasis on different things. The Paris Convention did harmonise them a little bit, but not by much. And then we had the harmonised rules for national trademarks that brought the law in the individual countries much closer together. But you still had an Irish trademark, a French trademark, a German trademark, an Italian trademark. Then we got the single EU trademark that you apply for in Alicante. You can see there the Swiss are doing their own thing still, and Norway's out. Don't forget Cyprus down here, all the way down here. Cyprus in the EU as well, or most of it anyway. Okay? And that's a single trademark that applies across all of the EU. I keep saying that because it's quite a remarkable thing. There are very few areas of EU law that are quite so advanced in terms of harmonisation. Okay? And these 2 systems then are running in parallel. That's an important point. So this leaves the question then, should you get a national trademark or an EU trademark? Well, it depends. So you might only be operating in a small geographical area. So if you are selling cars, maybe you're only going to be operating in Ireland. So Crazy Dan's car dealership, that might do you just for Ireland. And if someone in Greece has also set up a Crazy Dan's car dealership, well, it's not going to affect you. You don't care. It's no big deal. So you might opt for a single Irish trademark. That might be enough for you. And an Irish trademark will cost you about $250. Did I do the maths right? I thought it was more. About $250 for 10 years. So you can apply for €70, and then if you get it, you have to pay the other chunk of the money, and then that's good for 10 years. So it's cheap enough if you think of the price over 10 years. Whereas an EU trademark would cost you $850 for the 10 years. Now you can see how if you are going to be getting a trademark in lots of different countries in the EU, that the EU one works out quite good value, because there's 20 odd countries in the EU, and if they all charge the same as Ireland, you'd be spending a few bob to do them individually. So for a lot of businesses in Ireland, an Irish trademark, or say even an Irish and UK one, you might want to check before you decide on, strategy, deciding on a brand. Is that name available in the UK also and registered in Ireland and in the UK? A lot of businesses, that would be fine. Okay? Or you might opt for the entire EU one. Okay? If it turns out that your mark is unregisterable for some reason in any one of the EU countries, then it can't be registered. So if somebody in Cyprus is already using that trademark, for example, if it's registered in Cyprus, well, then you can't get an EU trademark for it. Now, you might say, but sure, I'm not doing any business with Cyprus anyway. It doesn't matter, we're not going to cross paths. That's not going to fly. So the mark has to be registrable in all of the countries, hypothetically, in order to be registered and as an EUTM. But you don't register it in each country. You get the EU one. Okay? So if something like that happened, then you might say, well, okay, I'm not going to go for an EU trademark because I can't. I still want to keep that brand or keep that trademark because I really like that. Then you might take the Madrid option and get an Irish, UK, French, German, Spanish, Italian, and so on, like that. And just not get the one for the one country that's causing you grief. Okay? So there would be different strategies. So a couple of different ways then you could get a trademark covering Ireland, for example. So you can apply to the trademark office. So the Irish Patents Office is where you'll get your trademark for an Irish trademark. You could just apply directly and get that there. You could apply for a mark in a Madrid Protocol country. So you could apply for a trademark in Spain and then designate Ireland as one of the places you also want to have it. And then the WIPO will take your money, send that on to the Patents Office in Kilkenny, and then they'll get back with a yes or no. Or you could apply to the EUIPO for an EU trademark, and that would then apply in Ireland. So a mark that's in circulation in Ireland and that has effect in Ireland could have come about by a couple of different ways. Now, despite all of that, and despite having trademark registration systems in place, passing away still hasn't gone off. So in some jurisdictions, just because it's a trademark register doesn't mean you have to register. So you can produce a product, or you can offer a business, you can offer a service, and you have two forms of protection. You have the protection that comes from passing off, and you could have the protection that comes from a trademark. If someone is acting the maggot, you might decide actually you might even have better luck in court with the passing off argument than with the trademark infringement argument, depending. So in many jurisdictions, like a non-registered trademark is still worth a lot. And you can still go to court and protect that. In some jurisdictions, you'd just be told, no, you didn't register, tough luck. No, in Ireland and in the UK, you can still get very, very far with an action for passing off without registering the trademark. Okay, but it does lead to some kind of strange anomalies. The advantage of having a trademark register is, if we recall the test for passing off, where you have to establish that you had a reputation, that there was deception and there's some damage. Well, when we have a trademark registration system in place, the advantage is that you don't have to demonstrate you have a reputation in the case of a trademark infringement. You just say, look, I have a trademark, I've registered it, and this guy's using it. The fact that no one's ever heard of you doesn't matter. You don't have to establish that reputation in the marketplace. So that's the first hurdle that's much more easily overcome. The deception issue is much the same. If someone is using something that looks like your trademark or something looks like your unregistered trademark, the test is pretty much the same. But then you don't have to demonstrate either that there was any damage done to you. Using someone's registered trademark without their consent is an infringement in its own right. It doesn't have to cause them any harm. They don't have to show that it caused them any harm. That you were doing that is enough to get you in trouble and get you stopped. So a trademark register does make life easier for owners of trademarks, because you don't have to resort to passing off to try and get their issues resolved. But passing off is still there in lots of countries. Which is interesting, because you think back to the business with the Statute of Anne and whether the common law copyright was replaced by the statute. The copyright that existed before the statute was gone. That right was done away with. Whereas here, the rights of trademark holders are still preserved using the old system and this new fangled trademark registration scheme. So any questions on that? So in the next class we'll look at actually what can be registered as a trademark and what the process is and the details of all that. So just to sum up then, very quickly, the trademark evolved from an issue of fraud where someone was defrauding the public and defrauding the maker to a property issue. So it's shifted from fraud to property. And the trademark registration scheme was motivated by the needs of international trade. It was always international trade was behind all that. And the reciprocity that this led to has given rise to like harmonisation and internationalisation. And the Victorians were very clever people. They knew what they were at. Okay, thanks very much, guys.